liability, check and see. Vicarious liability. Ada?
No.
Vicarious liability.
Yes, yes.
Ada? Okay. Okay, I'm going to go through on vicarious liability now. Yeah. Now, vicarious liability comes under law of tort. Vicarious liability comes under law of tort. Okay, have you heard of the word tort? T-O-R-T. Pernah dengar tak the word tort? Have you heard of the word tort? T-O-R-T. Give me a quick, feedback here.
No.
Before I go, yeah, I just wanted to find out from you all because I'm not very well versed with this. Yeah, the college actually they wanted to know whether all the students are attending the classes. So they said to copy and paste it into Moodle the whoever is attending today. But anyway, we are doing the attendance here. But I don't know how to save and paste into the Moodle. Yeah. But what I know is one is absent today. That is, who's the guy? Yeah, one is absent, right? The rest all in. Am I right?
Yes.
Only one guy is absent today, right? The rest all in. Yeah, if I'm not mistaken. Yeah. But anyway, never mind. Okay. Have you heard of the word tort? T-O-R-T?
No, never heard it.
Never heard of. Yeah. Okay. Now let me explain. Yeah. Okay. You all know what's a contract, right? You know what's contract?
Yeah.
Okay. Now, why am I doing vicarious liability here, not negligence first? Yeah, normally you should negligence and then only you come back to vicarious liability. But why am I doing vicarious liability first? Is because you have something in your class test in vicarious liability. That's why I wanted to make it that I cover this area. Yeah. Okay. Contract. Yeah, you all know contract. Yeah. The different. I'll try to explain what is thought based on. Um, Trying to draw a difference between law of tort and law of contract. Yeah, law of contract. Yeah, there is a contractual obligation between two parties. Am I right? In law of contract, there is a contractual relationship between two parties. That is between the two parties when they enter into an agreement. Both parties must fulfill whatever terms or obligation which they've agreed to undertake. Am I right? Okay, so for information, yeah, I'm drawing the distinction. I'm drawing a distinction between law of tort and law of contract. Yeah, and do you know that one part of the question itself touching on this? What's the difference between law of tort and law of contract? Yeah. Okay. Now let me explain. Take it down. Yeah. The difference between law of contract and law of tort. Yeah. Under law of tort, you have negligence, you have vicarious liability, you have occupier's liability, you have defamation, you have rules in Ryland and Fletcher. These all negligence, nuisance, all comes under law of tort. Tort. This all comes under law of tort. Yeah. Law of contract. You know what are the topics I've covered in law of contract, right? Okay. The difference between law of contract and law of tort is this. Yeah. Please take down. Yeah. Law of contract. There is a relationship between two parties, or there is a contractual relationship between two parties. Both parties must fulfill whatever obligation or terms which they've agreed to undertake as per the terms of the agreement. If either one of the parties did not fulfill the terms or the obligation in the agreement, that will lead to a breach. If one party has breached the agreement, meaning one party had suffered the loss. So the party which suffered the loss will sue. The party which suffered the loss will become the plaintiff, right? They'll become the plaintiff and they will sue the defendant. The defendant is the one who has breached that particular terms in the agreement, right? Will sue to recover for whatever loss, damage, or injury suffered, plus the interest, plus the legal fees, plus the court fees. Am I right? Is it clear? Hello?
Yes.
Anyone not clear? All clear. Okay, this is what you call as okay, because two parties has entered into an agreement with terms and conditions, because they have already signed the agreement, they must fulfill whatever obligation which have taken place. Am I right? That is, there is a contractual relationship between two parties, A and B. A and B is entering into an agreement, two parties. Both parties has put in all the terms and conditions in the agreement. Both parties must fulfill whatever terms and conditions which they've agreed to undertake. If they fail to fulfill the terms, or did not fulfill the terms, or did not fulfill the obligations in that agreement, then one party has breached the terms in the agreement, right? If one party has breached, that means one party will be suffering a loss. Of course, the party which suffered the loss would not keep quiet based on the contract. Am I right? They will sue based on the contract and recover for whatever loss, damage, or injury suffered. Am I right? Because of the contractual relationship between the parties. Whereas in law of tort, there is no relationship between the parties. In law of tort, very, very important here. In law of tort, there is no relationship between the parties. There is no relationship between the parties, but yet one party could be held liable towards the other. You see, even though there is no relationship between the parties, but yet one party can be held liable towards the other party, provided one party has done, an act which is unreasonable. One party has done an act which is unreasonable. If that unreasonable act could harm another person, then he owes a duty of care towards that person, even though there's no relationship. Clear or not clear, or you want me to repeat again? Hello?
Repeat again.
Repeat again. Yeah.
Clear, yeah, everyone clear, yeah?
Please repeat again.
Okay, I'll repeat again, yeah, very important, yeah? Okay, law of thought, yeah? In law of thought, there is no relationship between the parties. There's no relationship, let's say two parties, A and B. There's no relationship between A and B. But yet, one party, either A or B, could be liable towards the other. Even though they are no relationship, but yet one party can be held liable towards the other, provided one party has done an act, which is unreasonable. Provided one party has done an act or perbuatan which is unreasonable. If that unreasonable act could harm the other party, then he owes a duty of care towards the other party. I'll give you an example here. I'm driving the car at 200 kilometers in the North-South Highway. I'm driving my car at 200 kilometers in the North-South Highway. Okay? Do I owe a duty of care towards other road users? Even though I don't know who they are, do I owe a duty of care towards the other road users? Yes or no?
As long as below the speed limit lah.
Okay, I'm driving the car at 200 kilometers. 200 kilometers. Do I owe a duty of care towards other road users? Or I can even drive the car at 100 kilometers or even 80 kilometers an hour. But do I owe a duty of care towards other road users? I don't know who they are. Do I owe a duty of care? If I knock them, if I recklessly drive and knock them and they suffered an injury, do I owe a duty of care towards them?
Yes.
Yes, even though I don't know who they are, but because of the mere act which I'm doing, I'm doing an act which is unreasonable. If that unreasonable act could harm another person, then I owe a duty of care towards that person. So that means, I am answerable to that person for whatever loss, damage, or injury which I have caused to that person. Even though I don't know who that person is, but The mere fact I've done an act which is unreasonable. My unreasonable act has harmed him. So I owe a duty of care towards him. Okay, now this duty of care, yeah, was established. This duty of care was established in one landmark case. In one landmark case, yeah, called Donahue, versus Stevenson. I think, yeah, if I'm not mistaken, under lecture 8, yeah, I put negligence. Am I right? One topic is a topic called negligence. There, right? Actually, this comes under negligence, but I need to explain briefly a bit on negligence before I go into vicarious liability. Why I'm rushing to vicarious liability? Because of your midterm exam, you know. Okay, so now see what happened in this case, yeah. Donahue and Stevenson in 1932, you know. Where were you in 1932? Janice, where were you in 1932?
In the heaven.
Huh?
In the heaven, not yet come to the Malaysia.
In the heaven, yeah. Okay, you see what happened, yeah. You see, I just give you an example, yeah. In this case, yeah, 1932, you know, till today in Malaysia, we are following the law laid down in this case, Donahue and Stevenson. Donoghue versus Stevenson, Stevenson. This case here went to the highest court in England, that is House of Lords, you know. What happened in this case here? Very briefly, yeah. Okay, now, Mrs. Donahue, this lady, she and a friend went to a cafeteria. She and a friend went to a cafeteria. You know what's a cafeteria, right? Hello?
Yes,
know what-
yes.
Okay. She and a friend went to a cafeteria. The friend purchased a bottle of ginger beer. Her friend purchased a bottle of ginger beer. Mrs. Donahue shared and drank with a friend. The first part of the bottle, you know, it's a 1932 case here. When you're talking about 1932, we do not have a plastic bottle at that point of time, you know. All the bottles are opaque, you know. That means it's in glass, opaque. Opaque means it will be dark green, dark brown, anything. You wouldn't know what is the content. Now these bottles are very transparent. You know what is the content. Those days bottles here is not transparent, you know. It will be dark, opaque. So you wouldn't know what is the content. No? So first her friend drank the first bit pour, and then the balance she poured and she drank. While Mrs. Donahue was drinking, she came to know there was a decomposed snail. There was a decomposed snail inside that ginger bottle. So she drank. After drinking it, then only she realized there was a decomposed snail, you know. So she suffered from some gastrointestinal pain. She suffered from some gastrointestinal pain and she was rushed to the hospital. Okay, now the question is this, yeah. Now, can she sue the owner of the cafeteria? Can she sue the owner of the cafeteria?
Yes.
Okay, in law of contract, okay, now if we go back to, see, I'm trying to use this case to explain the difference between law of contract and law of tort, yeah? In law of contract, can she sue the owner of the cafeteria?
Yes.
Okay, Shirley says yes. Any others? Timmy, what about you, Timmy?
I
Timmy, are
think
you on the line?
I think should be yes. I think
Yes, also Liam. What about Shirley? Shirley,
Yes.
Shirley?
Yes, yes.
Okay. What about Atma? Atma, are you on the line?
I think yes.
Okay, all of you are telling, yeah? Yes, yeah. Okay, now you see, I'm going back. Did Mrs. Donahue purchase the bottle of drink or her friend? Her friend, right? Her friend is the one who purchased the bottle of ginger beer from the cafeteria. Mrs. Donahue shared and drank, but her friend did not suffer from any pain, because the friend is the one who entered into a contractual agreement with the owner of the cafeteria, because she's the one who paid the money and the drink was given to her. Mrs. Donahue only shared and drank. So there is no contractual relationship between Mrs. Donahue and the owner of the cafeteria. Of course, under law of contract, she can never sue the owner of the cafeteria. Am I right? True, isn't it? But her friend can sue, but she did not suffer from anything. She never suffered from anything, but Mrs. Donahue is the one who suffered. So that means, yeah, end of the day, under law of contract, there's no solution. No compensation for Mrs. Donahue. Can we let her die peacefully? And moreover, the owner of the cafeteria will turn around and say, hey, look here, man, I'm getting this from the supplier. I myself doesn't know there was a decomposed snail inside. Only now I came to know because the bottle is opaque. I myself don't know. Okay, can you go and, am I right? So there's no contractual relationship, right? Okay. So this is where the law of thought comes in. This is where the law of thought comes in. Because I told you, law of thought, not necessary, there must be a contractual relationship. Am I right? True, isn't it? You don't need a contractual relationship for law of thought. Am I right? Okay. Now, can Mrs. Donahue sue the owner of the cafeteria? What do you think now?
Yes.
Okay. But the owner of the cafeteria will say, look here, man, I'm getting it from the supplier. I'm getting it from the supplier. So only now I came to know there was a decomposed snail because the bottle is opaque. I myself don't know. Hey, why are you suing me? Go and sue the supplier. Can Mrs. Donahue sue the supplier? Here the supplier is, can they sue the supplier? Can or cannot? What do you think?
Can, I think.
Okay, you're saying can. What about any others? Any others? Shelley?
I think can.
Can, yeah. Janice?
For me, I think this is a very gray areas because some of people drink they maybe get harms of this drink, but some is not.
Uh,
I also think can sue.
okay. So I think can, yeah. Okay. So now if they were to sue the supplier will turn around and say what, hey, I'm only supplying to all the retail shops, Go and sue the manufacturer. Go and sue them. I'm getting it from the manufacturer. Go and sue the manufacturer. Am I right? True, isn't it? Okay. Now the question is, so in this case, the manufacturer is Stevenson. Stevenson is the manufacturer. Now the question is, go back to the root question here. Do the manufacturer owe a duty of care towards Donahue? Do a manufacturer owe a duty of care towards the Mrs. Donahue or the consumer?
Yes.
Yes. Yes, because the manufacturer owes a duty of care towards each and every consumer. I'm using the word consumer here, and I never use Mrs. Donahue, because sometimes the parents can buy the drinks and the children will be drinking in, and the children can suffer. Am I right? Okay, so for that, the answer is yes. Do a manufacturer owe a duty of care towards the consumer? They wouldn't know who are the consumer, but they owe a duty of care towards the consumer. Yes, to that question. Then the second question is, has the manufacturer breached that duty of care? Has he breached the duty of care? Has the manufacturer breached? First, we have already established the manufacturer owe a duty of care towards the consumer. Am I right? Okay, yes, that question. Then the second question is, has that duty of care been breached by the manufacturer?
Yes.
Yes, the breach here is the decomposed snail inside that bottle of ginger beer, right? That decomposed snail should not be there because that means they have compromised on the quality control. Am I right? So that is the breach. The breach is there inside the bottle of ginger beer. There should not be a decomposed snail. Okay, that was the breach. Yes to that question also. Then the third question: because of the breach, has the consumer suffered loss, damage, or injury?
Yes.
Yeah.
Yes. So here the consumer suffered from gastrointestinal pain. Am I right, Mrs. Donahue? Yes. So the question to the three question is yes, yes, yes. Then the manufacturer owes a duty of care towards the consumer. If one of the questions, the answer is no, then do not owe a duty of care. So here, all the three questions, the answer is yes, yes, and yes, then he owes a duty. This is how, even though he don't know who is the consumer, no relationship, but yet he has done an act which is unreasonable. If that unreasonable act could harm that person, then he owes a duty of care towards. Okay, see, during the trial of this particular case, in this case, it went from the lower court up to the highest court, the highest court in England is called House of Lords, and this case was decided in the House of Lords here. And the leading judge in this particular case was Lord Atkin, He was the leading judge who delivered the judgment here. During the hearing in the highest court here, this leading judge, Lord Atkin here, what, he put a hypothetical situation in the court, You know what he said, He said, he asked a question, do you owe a duty of care towards your neighbor? Do you owe a duty of care towards your neighbor? You have not seen your neighbor, you have not spoken to your neighbor, but do you owe a duty of care towards your neighbor?
Yes.
What do you think?
Yes.
Huh?
Yeah.
You have not
duty.
spoken to your neighbor, you don't know who's your neighbor, but do you owe a duty of care towards your neighbor?
Yeah, should be.
Yes. Yes.
Why?
Because neighbor,
Because neighbor means you have to owe a duty of care, is it? What
like
is it?
in indirect relationship. I don't know how to explain.
You see, you know what the judge said, Okay, if you do, okay, you see, now I put it again a bit further. If you do an act which is unreasonable inside your house, if you do an act which is unreasonable inside your house, and if that unreasonable act could harm your neighbor, then you owe a duty of care towards your neighbor. Let's say you are setting a fire to your house to claim for insurance. You have removed all your valuable things and you're setting a fire to your house to claim insurance. Of course, you're setting a house fire, but is it endangering the neighbor house?
Yes.
Yes, then you owe a duty of care because the mere fact you are doing an act which is unreasonable inside your house. If you do an act which is unreasonable, if that unreasonable act could harm your neighbor, then you owe a duty of care towards your neighbor. Even though you don't know who's your neighbor, you have not seen him, you have not spoken to him, but you still owe a duty of care under law of thought because the act which you're doing is an unreasonable act. If that unreasonable act could harm your neighbor, then you owe a duty of care towards your neighbor. This is how, you see, in all negligent cases here, these are the three questions raised in the court to sue the defendant by the plaintiff, All road accident cases, these are the three questions. Do the defendant owe a duty of care towards the plaintiff? First question. Second question, has the defendant breached that duty of care? And thirdly, because of the breach, has the plaintiff suffered loss, damage, or injury? And in fact, there's another fourth, the remoteness test. It must be within the contemplation of the parties. Sometimes the breach can be one thing, and the loss, damage, or injury can be due to third party. Then the defendant do not owe a duty of care. This I'll explain when I do on negligence. Just I wanted to differentiate between law of thought and law of contract. That's why I just said all these things, because this is, you need it also when you do on negligence. You see, I give you one case here. This is a Malaysian case here. The name of the case is Lee Kim Sai. Lee Kim Sai versus Abdul Latif. This is an accident which took place here. This is a 1978 case decided by the High Court of Kuala Lumpur, if I'm not mistaken. Okay. One place called in Kuala Lumpur, not in Kuala Lumpur, in Old Klang Road, Kuchai Lama. Have you heard of a place called Kuchai Lama? Hello?
Yeah. Heard before.
Kuchai Lama, Kuchai Lama, this accident, Okay. This Lee Kim Sai, he was riding his motorcycle along Jalan Kuchai Lama, this is, we are going back in 1978, or 72 or 78, I'm not sure. It's a High Court case, Okay, he was driving. Okay. while he was driving, you know, this guy, Abdul Latif, is the defendant. He's a road contractor. Abdul Latif is a road contractor, you know. Abdul Latif is a road contractor. He was doing some road work, you know. Once the road work is completed, he's supposed to remove all the particles and all the debris he should remove, you know. But what he did it, he left some of the iron bar at the edge of the road. He left some of the iron bars at the edge of the road. It has been there for a few months. It got corroded. It got rusted, you know. So this Lee Kim Sai, he was riding his motorcycle slowly. As he approached towards the iron bar at the edge of the road here, suddenly one child crossed the road. Suddenly one child crossed the road. So what he did here, to prevent hitting the child here, he swerved his motorcycle and he went and hit the iron bar at the edge of the road. He did. And because that was the rusted iron bar here, rusted one here, this guy was suffering from diabetic. When that iron bar pierced his leg here, he developed one sickness called tetanus. You know, tetanus here, tetanus. Sometimes they call it lockjaw, you know, you can't open your mouth, you know. And moreover, he's a diabetic patient here. The injury never healed. They have to amputate his leg. They have to remove his leg. You know. Okay. So he sued the contractor. Now, the question, the court is this in the High Court, and this was the question. Latif is the road contractor. He's the defendant, am I right? Do the defendant owe a duty of care towards the plaintiff? That was the first question. The plaintiff is the road user. The defendant is a contractor. Do a contractor owe a duty of care towards road users? Yes or no?
Yes, I think.
Yes. The question is yes, of course. Now the second question. Has that duty of care been breached by the defendant?
Yes.
Yes, the breach there is supposed to have removed all the particles or whatever debris or whatever from after the construction work. Am I right? He did not remove it. His duty, he know he's endangering other road users. Am I right? By leaving it there. So that was the breach. Then the third question. Because of the breach, has the defendant injured or any loss suffered or injury suffered by the plaintiff due to the breach of the defendant? Yes.
Yes.
Here a friend's leg has been amputated, has been chopped off because of his diabetic right. Yes. So these three questions, the answer is yes, yes, yes. Then the plaintiff will win a case in negligence under law. Even though he don't know who is Abdul Latif, but still Latif owe a duty of care towards the plaintiff because he has done an act which is unreasonable. If that unreasonable act could harm the plaintiff, then the defendant owe a duty of care towards the plaintiff. That means he's answerable to the plaintiff. So here you see, here very, very important here. Bear this in mind here, don't forget here. The defendant must owe a legal duty of care. The defendant must owe a legal duty of care. Only then is answerable to the plaintiff. Legal duty of care. Okay, example. Yeah, I give you an example now. Legal duty of care. Yeah. Okay, now let's say A is driving the car along the highway. In front of him, he saw an accident. Somebody knocking down a person who's walking along the road. Yeah, knocking him down and speeding off, never stop. And then you're going behind the car, and then you see this guy screaming in pain with the blood coming out from his legs and other parts of the body, you know. But you didn't stop the car to take him to the hospital. If you had stopped the car and take him to the hospital, he would have survived. But driving a new car, you don't want to take him in your car because blood stain and all the things in your car, right? So you never take him and you just waving bye-bye, peacefully die off, and you're driving off. Now, let's say this person dies. Are you answerable? If you have
No.
taken him to the hospital, you would have saved his life. But since you didn't take him to the hospital, he died. do you owe a duty of care towards that person? That is the question here now.
No, I think.
Shelley, you're saying no. So you see, so you see any accident, people suffering, you'll just wave hand, okay, bye, drive peacefully, and you drive off.
I mean, is it is it a duty for a human, but it's not a legal duty, because I'm not the one who bang him.
Correct. So here you have to differentiate between legal duty and moral duty. Legal duty, you are only answerable if you breach the legal duty. You are not answerable if you breach the moral duty. Moral duty, you are not answerable. But as a human, sometimes we owe a moral duty, right? But you cannot sue moral duty. It's depending on the individual whether they want to help or not. Breach of moral duty, you are not answerable. Only breach of legal duty, you are answerable. Clear? Because sometimes, in this kind of accidents, if you take him and then he dies in your car on the way, people think that you are the one who knocked him down, right? True, isn't it? True, isn't it? Nobody will know, isn't it? That
Yes.
that person has knocked and he has spit off already. Hit and run case, am I right? So for that reason, a lot of them, they won't stop, they worried, and then they have to go to court, this, that, police investigation and all the things. So to save all these things, they just drive off, True, isn't it? A lot of things happen, something like this along this line that, okay, just for your information, just wanted to differentiate between law of contract and law of thought. So now, do you all know how to differentiate between law of thought and law of contract? Hello?
Yes.
Okay, good. So that means one part you all are well versed already now in whatever exams, yeah? Okay, now I'll go into the next week, I'll go through on the negligence in detail, yeah? Just I wanted to go through vicarious liability now, yeah? Okay, the word vicarious, VICARIOUS, vicarious liability, LIABILITY. Vicarious liability means, yeah? Okay, this vicarious liability applies to employer and employee. Okay, now what do you mean by vicarious liability? The definition of vicarious liability I give you, yeah. Try to take down, yeah. I give you very, very briefly what you mean by vicarious liability. Vicarious liability means, yeah, the employer, taking down, yeah, the employer is vicariously liable towards the third party. The employer is vicariously liable towards the third party for whatever loss or damage caused to the third party by the employee of the employer. Okay, so that means here what I'm trying to say here is, yeah, the employer is vicariously liable towards the third party for the negligent act of the employee in the course of executing the duty. Get it? I'll repeat again, yeah. Vicarious liability means the employer is vicariously liable towards the third party for the negligent act of their employee in the course of executing their duty. Okay, don't get anything wrong here, please. Have you all got it right here? Or you want me to repeat again?
Repeat again.
Okay, see, only one person said repeat that. That means the rest all are very clear. So I don't need to repeat. Fair or not fair?
Repeat.
Okay. Vicarious liability means, the employer is vicariously liable towards the third party for the negligent act of their employee in the course of executing his duty. Get it? That is what you mean by vicarious liability. That means, yeah, I put it like this. Let's say I'm the employer. Okay, I have my company driver. I've given him some instruction to go and deliver some goods. While he's executing my duty, carrying out the duty, he negligently injured a third party while he's driving the car. He negligently injured a third party, and the third party has suffered a loss. I, as an employer, I am vicariously liable towards the third party for the negligent act of my employee. So I have to pay compensation towards the third party for the negligent act of my employee. Okay, now you get it? This is what you mean by vicarious liability. For vicarious liability to take place, you have to fulfill certain requirements. For vicarious liability to take place. You have to fulfill certain requirements. The first requirement, there must be an employer-employee relationship. That's the first requirement need to be fulfilled. The first requirement need to fulfill is there must be an employer-employee relationship. So that means, yeah, the person who has done the negligent act must be an employee. Only then I am liable towards the third party for the negligent act of my employee. You get it? Hello? Okay.
Yes.
So here when I say employee, yeah, because there are two types of employment under the Employment Act of 1955. There are two types, earlier, remember I said contract of service and contract for service. So I am only liable if it's under contract for service. Only those who are working in a company on a full-time basis, they come under contract of service. Okay, what do you mean by contract of service? Contract of service comes under Section 2 of the Employment Act 1955. It comes under Section 2 of Employment Act 1955. Okay, what do you mean by Section 2? What does Section 2 of the Employment Act says? Section 2 of the Employment Act says that there is an employer-employee relationship. There is an employer-employee relationship, meaning the employer is entering into an agreement with the employee with terms and conditions normally decided by the employer. So that means the employer is entering into an agreement, hiring the employee to work for him on a monthly basis. So that means only then he becomes under contract of service. That means he'll be paid a monthly salary, he's protected under the law, and all the protection he gets. The protection under the Employment Act 1955, he get the protection under the Industrial Relations Act 1967, he get protection under the Occupational Safety and Health Act 1994, he get protection under the SOXO Act 1969, he get protection under the EPF Act 1991. All the protection is given if you are an employee. That means if you fall under Section 2 of the Employment Act 1955. So that means contract of service. So that means here, if you are given a letter of appointment to work in a company, that means you are under contract of service. That means you are an employee of the company. So you are protected under the law, and also there are rights and duties of you. So this vicarious liability only applies for contract of service. Sorry, it only applies for contract of service. Only contract of service, there is an employer-employee relationship. Contract for service doesn't fall under Section 2 of the Employment Act. It doesn't fall under Section 2 of the Employment Act. That means there is no employer-employee relationship. They are what you call as independent contractors. So the vicarious liability doesn't apply for contract for service. It only applies for contract of service. For service means, let's say I'm calling the Grab driver to take me to airport. On the way, he's coming to my house to fetch me. He met up with an accident. Am I liable? No. Electrician, motor mechanic, they all are independent contractors. They come under contract for service. There is no employer-employee relationship because they are not paid the EPF, they are not, they SOCSO contribution, am I right? They are contract for service. So this vicarious liability only applies for contract of service. There must be an employer-employee relationship. Clear? Hello?
Yes.
Okay, that is the first requirement. Contract. There must be contract of service. Okay, the second one, the instruction should have come from the employer, either the employer or anyone appointed by the employer to carry out the duty. Can be the manager, can be the supervisor of the employer, giving instruction for the employee to carry out the duty. So the instruction must be given by the employer or anyone appointed by the employer to give the instruction. Here normally either the supervisor or the duty manager or anyone. That is the second requirement you need to fulfill for vicarious liability. The third requirement, it should have taken place while executing the duty. So that means, while he's carrying out the duty, when he's physically carrying out the duty, when the employee is physically carrying out the duty which was given by the employer or his anyone authorized to give the instruction, while he's carrying out the duty, this negligent act has taken place. It must be in the course of executing the duty. This accident should have taken place. Okay, so here you see.
Teacher, what you mean is like when the worker is working then accident happen, then only will cause the vicarious liability.
If there's no accident, why should I pay the third party? Am I right?
Yeah.
Isn't it? So here, you see, okay, now, you see here, you also need to know, there should not be a detour, if there's a detour, employee is not liable. You know what's detour? D-E-T-O-U-R, detour. Okay, now, I given my instruction to my my employee to deliver goods from point A to point B. So he has to drive his vehicle from point A to deliver goods at point B and collect goods from point B, bring back to point A. That is duty. That is the normal routine of his duty. But what this employee is doing, he's supposed to go to point B. But what he's doing to meet his friend, he's going to point C. After meeting his friend from point C, and then he's driving to point B. While he's driving from point C to point B, an accident has taken place. So here they have done a detour. Then the employer is not liable. Then the employer is not liable. But as far as the third party is concerned, the third party has suffered an injury. As far as the third party is concerned, he couldn't care less whether he has done a detour, but he is an employee. He's an employee working for the employer. He will only sue the employer. Am I right? I'll come back to that later. Okay. That is the third one. Am I right? The fourth one is there must be loss, damage, or injury suffered by the third party. For vicarious liability to take place, the fourth requirement is there must be loss, damage, or injury suffered by the third party. Only then the employer is vicariously liable towards the third party. So that means first, there must be an employer-employee relationship. Second, the instruction should be given by the employer. Thirdly, that negligent act has taken place while executing the duty. And fourthly, there must be actual loss, damage, or injury suffered by the third party. Only then the employer is liable towards the thing. Okay. So these are the situation, yeah. So these are the requirements the employer need to fulfill for vicarious liability to take place. So it must be contract of service. There must be an employer-employee relationship. If there is no employer-employee relationship, then the employer is not liable. It doesn't apply to independent contractors. Independent contractors, they don't fall under Section 2 of the Employment Act 1955. Motor mechanic, electrician, they provide a service, you pay them for the service, off they go. Am I right? You do not owe any duty of care. Even your house, you need some work to be done, a plumbing work in your house, and you've called the plumber. The independent contractors, am I right? Let's say it's coming down to your house. On the way, you might have an accident. Are you liable? No, because you are not. There is no employer-employee relationship. They provide a service, you pay them for the service, off they go. Are you following? Okay, what I will do, yeah. Yeah, yes, any question, Shelly? Any question, Shelly?
No.
Okay, this is the first thing, and these are the requirements need to be fulfilled by the employer. Okay, the next class, what I will do here, the next class, I will do what, yeah, I'll tell you why they're making the employer liable. Why are they making the employer liable for the negligent act of the employee? Here, the employer has not been negligent, only the employee has been negligent, am I right? Why are they making the employer liable towards the third party for the negligent act of the employee? Am I right? So here the employee is not negligent, only the employee is negligent, right? But why are they making the employer liable towards the third party for the negligent act of the employee? So I'll go through on this and I'll give you all some cases, because you need this for your midterm, your class test. That's what I do. It carries 50% of the mark. Am I right? Okay. Okay. Now Monday, shall we have from 11 to 1, or how class rep?
I think can 11 to 1 ah. So the afternoon we can all do our own things ma.
Okay, all right. Okay. So what we'll do Monday, I'll meet you all at 11 o'clock. What I will do Monday, yeah, I'll finish off the viability, and then I'll go into your negligence or your occupational ability. Okay, I wanted to cover up all the areas before you all go for your class test. Because that's week 10.
Okay.
Betul kan? Okay, this Monday I'm having just this is between. I just want to do a service for you all, because you know why? Normally your class is supposed to be 3 hours, but I don't know how they make it only 2 hours. Am I right? So I feel it's very unfair to the students here. This I'm doing voluntarily for you all, not being paid to anything. You know, I'm just doing just with my own initiative. I'm doing for you all. The Monday class. Yeah. Okay. In between, you all have any question, you all can ask me also. You can always WhatsApp me. All right. Hello.
Okay, thank you, teacher.
Okay. So see you.